This conference will now be recorded.
There you are. I know it's recording now. Okay, welcome to HMO's Houses of Multiple Occupation, a basic overview of the law, what's required. As I said in the intro before I hit the record button, it's probably one of the most ambiguous and most complex areas of housing law. It probably rivals it with deposit compliance, which is, for those that sat on last week's course, where we covered deposit compliance, it is very similar in terms of its detail and also potentially the ambiguity of how the legislation is written. So I'll go through the basic summary in terms of what is a HMO, and then we'll look in a bit more detail at the HMO Management Regs 2006, which for me is probably the most important part of HMO legislation. It's the part where criminal sanctions and criminal prosecutions could happen if an agent or the person deemed to be managing the property doesn't do it correctly. So for me, that's probably where the consequences of not getting HMO legislation right and managing HMOs correctly could be seen to its full effect. So we'll have a look at that in a bit more detail on the second half of this particular webinar. So housing or houses of multiple occupation and the sort of consequence of the legislation came through, as most of you will probably know, came through in the Housing Act 2004. So the Labour government brought out the Housing Act 2004. It contained lots of other things which you may be familiar with, such as deposit legislation. It also brought out that acronym, which I can say, which is HHSRS, which is Housing Health and Safety Rating System. But it also brought out a more detailed understanding of HMOs. So I won't go into the old definition of HMOs because we don't have the time here today. But the government brought out legislation because very clearly the statistics showed there was a higher risk of persons living in HMOs. The problem that you've got, or the problem that we now have, is the way they defined HMOs in 2004 was quite ambiguous. And the way they defined it, it actually catches a lot more properties under the HMO definition than probably was intended by government. The unintended consequences of legislation is what we feel on a daily basis being letting agents and landlords, but it probably has most definitely applied in this particular case. So the reason, as I said, the reason why government brought out legislation, more legislation in relation to HMOs, is because of the statistics. And the first one, which I always, and for those that follow me on LinkedIn, I've got a bit of OCD about fire safety, because for me, it's probably one of the most underrepresented areas of safety that agents do or don't do in this particular scenario. For me, there's more danger in terms of fire risk than there is in Legionellas or potentially carbon monoxide poisoning, personally. So I fully understand the reasons why government want to take a harsher stance in relation to fire risk assessments. But for me, that should be across the board, not just in relation to HMOs. But the statistics showed in terms of HMO legislation and why they brought out the legislation was that you're 6 times more likely to die in a fire, which is a HMO. And the very simple logic is that if you're not related to someone, you're less likely to try and assist them in the event of a fire. And if you just talk about all the dodgy hotels that I stay in, if a fire went off in my particular hotel, then it's very unlikely that I would be running around the hotel knocking on different rooms to make sure that those persons or those occupiers got out of those rooms. My selfishness would probably say that I would just worry about myself and not worry about anyone else. And that's the basic sort of logical interpretation of those statistics, that, you know, in the sense that if you are related to someone and you had a fire in your own family home, it's highly likely that you would try and save everyone in your family as best as you could. So that's the reason why there is high fatalities where a property is defined as a HMO. And the other one, which they look at, and this is quite a high statistics in terms of the multiplication, you're 16 times more likely to suffer a fatal injury in a HMO of 3 or more stories. Now, that's ultimately about people jumping out of the windows, I was assuming, in the event of a fire, because you're less likely to survive, obviously, or you're going to suffer serious or fatal injuries if you did jump out of a third floor building. So that's the reasons why HMO legislation was brought in much more detail in 2004, because the statistics very clearly showed that that was the situation. Now, as I said, what they've then done is they've brought in legislation which is overkill. They've brought on all this legislation, which you'll see over the next few slides, which then puts a huge onus upon agents and landlords that deal with properties that are HMO in relation to how they manage the HMOs in terms of fixtures and fittings, and also fire safety. I understand the fire safety part 100%. What I don't understand to a certain degree is all the other things that are required by an agent or the person deemed to be managing the property, which for me is way beyond what they interpret, or way beyond what they required, or probably were going to put into the legislation back in 2004. But that's what we've ended up with. And the problem you've got is that you have overzealous, over proactive, if that's the right way of phrasing it, council enforcement officers who look at the legislation and take it to the letter. And believe me, and I know there'll be a number of landlords and agents from Nottingham, but yeah, I had a client in Reading, and it's the one I always refer to because I actually saw the charge sheet, if that's the right way of saying it. So my client in Reading, who actually had a 4-bedroomed student let. So it wasn't mandatory licensed, but it was 4 students under 1 joint tenancy. So they all knew each other, but they were obviously friends, but they weren't related. So therefore, it fell under the definition of a HMO. They were quite awkward in relation to the way that they lived at the property in terms of cleanliness, etc., which I'm sure those that deal with student lets will probably tell me that's quite a common occurrence. And they were quite awkward in terms of they thought their parents thought they knew everything, which is another issue when you're dealing with students, which I'm sure some of you will tell me is again quite a common occurrence. So there was a couple of issues regarding repairs that needed doing there, which the landlord had no problem about dealing with, but there were issues with access. I think the tenants were being quite awkward in access. So I think in a sense what they did is they sort of bypassed the agent and they complained straight to the local council. And as soon as they complained to the local council had an obligation to go and visit the property and undertake a HHSRS inspection. But also, as you'll see later on, they had also an obligation to deal with and comply with the HMO Management Regs 2006. So my client actually then got a letter from the local council, which in this case was Reading Borough Council, and asking him to come down for an interview down at the local council. He actually turned up at the council and they actually interviewed him under caution. So they actually taped the interview and they went through all the things that they found at the property under the HMO Management Regs 2006. And a couple of them were what I would class as almost ridiculous. One of them was a dirty toilet seat and the other one was a dirty shower tray. Now, under the HMO Management Regs 2006, they actually fall under the landlord's duties or the manager's duties. So the landlord or manager had no real ability to affect whether the shower tray or the toilet seat were clean or not. But in this particular instance, because of the time and the date that the environmental health officer visited on that particular visit, they were dirty. So therefore, the manager of the HMO was the person that was held to be liable. Now, subsequently, they were dropped, but it went through this for about 3 or 4 months, and the particular environmental health officer was being very, very overzealous in terms of what he was trying to charge my client with. So these are things that we have to deal with when we're dealing with HMOs, and that's the important thing to remember. When you are dealing with a HMO, whether it's a licensable or unlicensable HMO, you have a higher level of obligations in relation to management of that property. And then that's the important thing to remember. And that's why some of you as agents will certainly charge a higher fee in relation to managing a property, which is a HMO, because evidently there is a lot more management involved with managing a HMO. So I have no issues about you charging more, because in the end, you will be doing more work in relation to a HMO. in terms of prosecutions, and these are two recent ones in the last couple of years, just to show you potentially what councils will prosecute under. And these are all under the HMO Management Regs 2006. That is separate to HHSRS. So Housing Health and Safety Rating System is not a criminally prosecuted position unless you don't do the works in relation to the improvement notice that you receive. The HMO management regs are what I'm going to refer to as proactive, in the sense that if you don't do them, you don't get notice to say that you haven't done them, you potentially just get a fine straight off. So that's the difference between HHSRS, Housing Health and Safety Rating System, which is reactive. They visit, they tell you what's wrong, and then they give you time to fix it. Unlike the HMO management regs, which is proactive, as in the sense that if the tenant complains, the local council visit, they can just slap you fines without even you having the ability to react. So that's why it's so important to understand the difference between the two mechanisms when you're dealing with managing a HMO. So in this particular instance, this particular landlord in Lincoln, February 2020, so just before COVID, they were fined £5,500. And you can see the points on there. So the gas meter cupboard in the ground floor corridor was not enclosed and fire resistant. Polystyrene tiles on the ceiling. Again, that legally from a legislative perspective, polystyrene tiles are allowed. If they were fitted in 1970 and they're still there today in 2021, from a building regs perspective, as some of you all know, that's fine because you were compliant with the laws when it was first fitted. But under your HMO management regs and also your fire risk assessment, that should not be in there. So if the council visited and they had polystyrene tiles on a HMO, even though you may not have thought that was an issue, because the council think it's an issue, and it definitely is, if I'm being completely honest, then you would be slapped with a fine, and you would have no ability to react to that fine, because in the end, it should have formed part of your fire risk assessment when you first moved the tenants into that particular property. And then again, the last point on, there's significant gaps around the fire door. Now, not all properties require fire doors in terms of HMOs. The smaller HMOs won't require fire doors in the majority of cases. As you probably know, in mandatory licensable HMOs, there's a very good likelihood that they would require you to have fire doors. But as a general rule, you don't for the smaller HMOs. But each property will be slightly different based on your fire risk assessment. So if you've got a 4-bedroom modern detached house and you've got 4 friends sharing under a joint tenancy, the chances that you'll be required to have a fire door on the livable rooms is not that likely. Now, that will depend from council to council and how the councils feel. Some councils will be more proactive or more insistent. Some other councils will take a lesser view. It just depends on what the environmental health officer says. So again, it's always hard to dictate or for me to define exactly what you need for each HMO, because it will be a horses for courses scenario in relation to HMOs. But they were fined £5,500 in that particular scenario. As I said, they could just turn up and do this under the HMO management regs, and you could be fined automatically without any recourse in relation to having been given notice that they were things that were wrong and you should have put them right. The councils can be quite awkward in that sense, and I know for some of them, I know John's in Bristol, who are quite a proactive council, Paul's in Nottingham, who I know again are a very proactive council. Luckily, I come from Bournemouth on the south coast. I have a very good friend who's an environmental health officer. He's very lax in the sense he's quite informal. He would actually have a very good conversation with a landlord before he even considered slapping a fine on you under HMO management regs. The last thing he wants to be doing, in his words, is paperwork. So he's quite good in that sense in relation to having a good conversation with you over the phone about what he thinks may be wrong with a particular property. And if you've got a HMO, in the end, there's no reason why you can't ask the council to come out and have a look for you and to give you any recommendations about what they think that should be in that HMO. I mean, that ultimately is their job. That's what they're getting paid for. That's why we're paying tax. That's why we pay tax. It's for people like that to try and help us out in relation to good practice and recommendations for a particular property. The second prosecution, again, in sort of the East Midlands area. I'm not picking this out. I haven't picked these out purely because they're in the East Midlands. They were good ones to look at. So again, this was a company landlord. But again, this is all about really fire safety. And as you'll probably be aware, that is probably where most of the prosecutions happen. It's about fire safety. Now, as I said, going back to that Reading Borough Council situation, you know, a council worker saying we're going to fine you because you have a dirty shower tray is way beyond what I think the government intended when they brought the legislation out in the first place. But because the legislation is worded like that, then some council officers will interpret it in a certain way, whereas others will not. And that's always the difficulty. In one council it will be fine, and one other council it won't. So a lot will depend on what your council are like in relation to enforcement. Some councils are very lazy, some councils are very much more proactive. And I'm sure some of you will tell me how proactive or unproactive your local council will be. Okay, let's go on to what is a HMO, because that's probably and I know I've covered, for those that have been on my basic law course, I fully appreciate you will probably remember this this particular slide, but it's so surprising how many people still forget what is a HMO. Now, the way of looking at it, for me, the only way of looking at it is, in the majority of cases, 99.99% of the time, a HMO is defined by the people living in the property. So it's not the building that will make it a HMO, it's the people within it which will make it a HMO. So the very simple definition from my perspective, and I fully accept there are lots of different definitions out there, but for me, this is the simplest. Now, if you look on council websites, they will start talking about 2 households, which for me confuses people. Now, I fully accept the way I explain it may confuse people, but for me, that's the easiest way I teach. So the very simple definition is a property where 3 or more people who are not all related. Now, for me, that's the simplest way of doing it. 3 or more people or occupiers. It doesn't say the word tenant, so you need to bear that in mind. So we're not looking at the tenant. So if you've only got 2 tenants, that does not mean it may not be, that does not mean it's definitely not a HMO. It may be a HMO because there may be other people living there that then make it a HMO. So a property where 3 or more people who are not all related. So my very simple example is that I've got 3 friends sharing a three bedroom house under a joint tenancy. That very simply is a HMO. It may not be a licensable HMO, but it is most definitely a HMO under the Housing Act 2004. And any property that's defined, or any tenancy, if that's the way you want to say it, that's defined as a HMO, has to follow the HMO Management Regs 2006, and that's where the criminal prosecutions come out of it. So the important thing to understand is my property a HMO? Now, in most cases, it will be very clear that it's not a HMO. But in certain circumstances, it will be a HMO, but it's your responsibility. Hello, Henyu, nice to see you with your headphones on. Yeah, in most cases, it's your responsibility as the agent or landlord to identify that, and that's why it's so important that on your application forms you have those questions. Now, John, I think John deals with a lot of students. I think Paul deals with some students as well. So in the majority of cases there, it's going to be very clear it's going to be HMO because most students aren't going to be related to each other. So in that particular instance, you'll know automatically it's a HMO. If there's 3 students, that is going to be a HMO because in most cases, those 3 students won't be related. But in other scenarios, you might need to ask those questions. It's not the responsibility of the tenant to tell you whether they are a HMO or not, because they're not going to know. The law doesn't give the obligations upon the tenant to tell you. It's your obligation as the agent or landlord to understand, is my tenancy or is this particular property or this particular set of tenants going to be a HMO? So asking those questions at the very start of the whole process is really important. How are people related to each other? So I had one the other day. I think one of my clients was saying to me that he had 3 Middle Eastern tenants approach him. They all had different surnames, and he said, "Is it a HMO?" And they said they're all cousins. And then he said to me, "Daryl, how do I identify whether these people are all cousins? Because that's what they're telling me." Because he goes, they're based in Newham. So Newham, for those that know London, Newham is quite an awkward council. So he said to me, "Look, I don't want to go ahead with this because in the end, he says, I don't want to be in an awkward situation with the local council if they say it's a HMO and it's not." or if I'm saying it's not a HMO because they're all related. So what evidence do I need? And I say, well, you can't really take blood tests because that's probably a little bit OTT. So you've asked the question. The tenants very clearly identify to you that they are all related because they are all cousins, and they don't have to have the same surname to be cousins. So you've got to take it at face value. So therefore, you've asked the question. It's very clearly evidence that it's not a HMO. And therefore you can continue on that basis. Now, if it suddenly transpires that it is a HMO, then you can have to manage it as a HMO. But I don't think the councils are going to be taking blood tests either. So from that perspective, you've asked the question, I think you'd be sufficient enough in relation to your due diligence in terms of whether it's a HMO or not. But asking the questions in the first place is the important part. So I've got to identify, is this tenancy going to be a HMO? I'll ask those questions, and from that, I should be able to identify whether it's a HMO or not. So it's 3 or more occupiers. That can include children as well. Then we aren't just talking about adults. It needs to be children as well. Also, just to make you aware of it, and I haven't got a point on the slide on this, it needs to be the main residence of at least one of those joint tenants. So, for example, if I had 3 contractors renting a property from us, but they were just working on, say, Crossrail Monday to Friday, and that weekends they were all going home, that would not be their main residence for the purposes of the Housing Act 2004. So therefore, even though they are 3 unrelated people, because it's not their main residence for the purposes of the Housing Act 2004, that would not be a HMO for the purposes of the Housing Act, just to make you aware of that, just in case you have contractors that work or people that are renting properties from you where it's not going to be their main residence. So from that perspective, as I said, the problem you've always got is that, especially in terms of people's relationships will change from time to time. And over COVID, that happened frequently. So my very simple example again is that you could move in Janet and Jane, for those that have been on my HMO courses before, Janet and Jane move into one of your properties. Is that HMO? No, it's not. Why? Because there's only 2 of them. There's only Janet and Jane. So that's fine. Under the Housing Act 2004, Janet and Jane are fine. They're 2 friends, but because there's only 2 of them, it is not a HMO. Janet and Jane, Jane is pregnant. She's got a partner who's not living with them, and a new baby is introduced into that particular tenancy. So there's Janet and Jane and Jane's baby. All of a sudden, that's gone from a non-HMO to a HMO because of the new person, in this case being the baby, being brought into this particular tenancy stroke property. So we've now got Janet, Jane and the baby. So we've hit the 3 person or the 3 occupier threshold. And because Janet and Jane are friends and not related, that then becomes a HMO because they have to be all related for it to remain under the family definition. So Janet and Jane, when they first moved in, was not a HMO. Jane's brought the baby in. It now becomes a HMO because they are not all related. Now, there's a little bit of wriggle room. If Janet and Jane got together as a same-sex couple, then that would join up all the dots, and they would then become all related for the purposes of the Housing Act 2004. Now, I have to give the draftsman, the person that created the legislation in the first instance, some leeway on this, because in the end, trying to write legislation to cover people's relationships is going to be almost impossible, and that's what's happened here. So people's change in relationships can create a non-HMO in the first instance, but it then can become a HMO in my very simple definition. So even though you don't want to let a HMO or you don't want to manage a HMO, you could become a HMO manager by default because of the change in a tenant's circumstances. So that's always something you need to remember. So if you do become aware of a change in circumstance, then potentially you may need to consider that you need to manage this as a HMO. Worst case, in a sense, that you may even have to apply for a license to manage that HMO. So these are the things that you need to take into account. I'm not saying the councils are going to be overly zealous upon you. If you weren't aware of it, they may have a little bit more flexibility in terms of what you should or shouldn't do. But if you do become aware of it and you still don't act, then potentially you could be held liable under legislation in relation to not having a license, but also not managing the property in accordance with the HMO Management Regs 2006. So that's when the people make it a HMO, and in the majority of cases, 99.99% of the time, that is how a HMO will be created in terms of how you manage one. It will be the people. Hence why I reiterate, you've got to be asking the right questions at the very start of the tenancy or the application process to identify whether it is a HMO or not. I wouldn't worry about this one too much, but you might hear about it. It's what they refer to as a Type 5, Section 257 HMO. Now, Section 257, strangely enough, comes from Section 257 of the Housing Act 2004. So if you ever hear a council officer say, you've got a Section 257, this is what they mean. So it's not really going to be that common to you guys, but I just wanted to make you aware of it, just in case you ever hear the phraseology. So it's a conversion not compliant with the 1991 building regs and less than 2/3 are owner occupied. So my very simple example, I've got a Victorian house, which has been converted into 5 self-contained flats. It was converted in the 1960s, so before the 1991 building regs. The 1991 building regs was all about fire safety. And less than 2/3 are owner occupied. So you've got basically 3 of the flats being rented and 2 of the flats are owner occupied. That building would be defined as a HMO. So it's not the people per se making it a HMO, it's the way the building has been converted, which makes it a HMO. So for those that potentially own the freehold on those types of properties, you may need to understand whether you have a HMO or not. But as I said, I won't go into that too much, but just in case you do ever hear the phrase a Section 257 HMO, that is what the councils will mean. You have a conversion which is not compliant with the 1991 building regs and less than 2/3 are owner occupied. Is that okay? But we're going to really concentrate on the people because that's the important part in relation to what we do on a daily basis as agents or landlords. I haven't got that many slides on the people because there are quite a lot of slides on a full day course in relation to all the different relationships. So I'm going to be very brief in terms of what the relationships are, because the legislation then defines how people are related. So there are lots of definitions, and that's what I'm trying to say. This was written in 2004, and we've had so many changes in potential definitions of relationships and gender and all those things as well. So I assume at some stage we may have an update on HMO legislation. I think the government are a little bit busy doing other things at the moment rather than worry about HMO legislation. But it would be good if they did an update at some stage, which I think they will probably have to do because life has moved on a little bit from when they first wrote it in 2004. So the single household they talk about, so you are related if you are partners or those persons are married to each other or live together as husband and wife in equivalent or an equivalent relationship in the cases of the persons of the same sex. So as in my example earlier, if Janet and Jane got together in a same-sex relationship, then they would be deemed to be related. And therefore, Jane's baby would be related to Janet through her relationship with Jane, if you understand that. So that's where we are going in relation to relationships. It is quite confusing, but just be aware that if they tell you they are in a relationship, I don't know what test you could do. I suppose you could sit them down together. I don't know. I'm trying to think actually. I'm sure there are lots of different scenarios you can think of trying to work out whether or not they were actually together in a relationship. But if they tell you they are in a relationship, you've got to take that as what they're telling you is true. So those persons are married to each other or living together as husband and wife or in equivalent relationships of the persons of the same sex. So that's partners, and then they talk about relatives, and then there's a whole list of relatives. Relatives means parent, grandparent, child, grandchild, brother, sister, uncle, aunt, nephew, niece, or cousin. Then people start talking to me. What about second cousins and third cousins and fourth? It only talks about cousins in the legislation, so I'm going to assume they mean first cousins. Otherwise, how long's a piece of string? But again, as I was saying earlier, if they're telling you they are cousins, you've got to take their word for it. I mean, I assume they're not going to really understand HMO legislation and they're not going to try and avoid it. So in that sense, if they do tell you that they are related to cousins, I think you're going to have to probably take them at face value, unless you believe they're lying for any particular reason. Then you wouldn't take them on as tenants anyway. But if they're telling you that they are cousins, then I would assume that's what they're telling you is probably true in relation to being related. I am mindful of time, and it's already 3 minutes past. So I've got to quicken up, I'm afraid, because there's a bit about the HMO Management Regs 2006. So yeah, and then they talk about half blood. So half blood equals full blood, and that's what they're probably talking about in this particular definition. Let me just go back. One of them is or is a relative of one member of the couple, and the other is a relative of the other member of the couple. Now, all I can say in this particular instance is that wording is not something that I have written, thankfully. That is word for word out of the legislation, just to make you aware of that, because it doesn't make much sense to people when they first read it. It does eventually when you've read it about 6 million times. It does make sense. So in my Janet and Jane scenario and the baby is related to Janet through Janet's relationship with Jane, the mother. That's the reason why Janet and the baby are related, not because Janet's the mother of the baby. It's because she's related to the baby through Jane and having a relationship with Jane. But obviously, in the first instance, in most cases, Janet and Jane are friends, so therefore the baby is not related to Janet because Janet and Jane are not in any type of relationship apart from being friends. But being friends is not defined as a relationship under the Housing Act 2004. Maybe they should include it. Maybe that would make our lives a lot easier. And the government just put in a clause in the Housing Act 2004 and said, if you are a friend of someone, then you are related. That would make it nice and easy. Because I'm sure there's lots of friends who will try and save each other, but sometimes actually being related is probably a worse part. There might be a situation where you don't mind not trying to save them without sounding too cynical in relation to relationships, etc. Is that okay in terms of people? That's the people side of it. There is another raft of legislation above that as well, but from my perspective, in terms of a brief summary, I think that is sufficient for today's purposes. If any of your tenants are lucky enough to have two servants, then two servants are deemed to be related. So if any of you have a gardener or a chauffeur or a nanny or a cook, then they are deemed to be related for the purposes of the Housing Act 2004. So if one of your tenants brings, there's a family and they've got a cook and a nanny, then the cook and the nanny under the Housing Act 2004 are deemed to be related for the purposes of that position. So they would be deemed to be part of the family. And also two lodgers. If you have two lodgers, again, no more than two, then again they would be defined to be part of the family. So if you had a live-in landlord who was renting out two rooms to lodgers, those two lodgers under the Housing Act 2004 would be deemed to be related to the live-in landlord. If he or she had three lodgers, then that would be a HMO because only two of them would be deemed to be related. The third one would then make it a HMO, if that makes sense. And the landlord would have to manage the property in accordance with the HMO management regs and potentially apply for a license, depending on the local council. I missed the next slide because we don't have time. That's just a test, but we won't do a test today. You'll be glad to hear. I'll go on to very quickly onto licensing because obviously licensing applies when we have HMOs. So as you probably are aware, there are two different forms of licensing where HMOs are applicable. So we have mandatory licensing, which I'll talk about in a bit more detail on the next slide, and we have additional licensing. The reason why they're important is because they come with criminal sanctions and financial sanctions where you've not done it correctly. So we have fines that if you've not done or if you've not got a license when you should have a license, and then we have rent repayment order or orders where the tenant can claim back their rent for the last 12 months where you haven't had a license. So mandatory licensing is applicable across the whole of the country, not dependent on the local council. Additional licensing is applicable on whether or not the local council bring it in. So most student cities have some form of additional licensing. So Bristol, for example, will have it in certain areas. Oxford have it across the whole of the city, that any property that's defined as a HMO, it requires a license if it's not covered by mandatory licensing. But we'll talk about those in a bit more detail on the next two slides. And I am mindful of time, and it is almost 10 past 12 already. Just trying to think, yeah, quarter past we finished. So this is a mandatory license for HMO. So again, this is a legal requirement. It's irrespective of what council you fall under. So 5 or more occupiers, not all related. So 5 friends sharing is a HMO, mandatory license for HMO. A family of 4 and a friend, that is a mandatory licensable HMO. 2 families, mum and dad, 2 sets of mum and dads with 1 child each, so there's 6 people in total. Again, that is a mandatory licensable HMO because those 2 families are not related in any way, which I know is quite common in certain cultures in London where they will have a number of families living in the same property. So just be wary of that. As you probably know, they've removed the 3-story limit. So in the olden days, if it had to be 3 or more floors, now it could be 5 students in a 2-story townhouse. That would now be defined as a mandatory licensable HMO. The only exemption to, or the 2 exemptions to that, is one where it's a flat in a purpose-built block of 3 or more self-contained units. So you've got a ground floor flat with 5 students sharing that ground floor flat, but it's built in a purpose-built block of 10 stories with at least 10 self-contained flats. That would not require a mandatory license. It may require an additional license, but it doesn't require a mandatory license. And that's purely, I assume, because it's purpose-built. Because it's built with all the current fire requirements in it, it's highly unlikely that there's going to be a huge fire risk. Hence why they probably don't fall under mandatory licensing, but it could fall under selective license. Additional licensing, depending on the local council. And it doesn't include Section 257, what we talked about earlier, where the building makes it a HMO. So just to make you aware of that. But that's mandatory licensing, where there's a national requirement for it. I don't know if there's any questions or if everyone is multitasking, as they said they were going to be doing. I saw Henry having a cup of tea. Henry, thanks for the offer of a cup of tea, but that's life, I suppose. No, Chinese tea. I'm surprised you're not drinking Chinese tea. I see you on the coffee, were you? Happy New Year for you as well, Henry, because it's the Year of the Tiger on Tuesday. Is that right? Is it Year of the Tiger?
Yes, but on the 1st of February, it'll be Year of the Tiger.
Yeah. I'm off to Bayswater for a nice Chinese lunch dinner. So that's where I'm off to. Anyway,
When are you going?
Monday night we're out for a meal Monday night. So yeah, we're going to Bayswater. If you're about,
Okay, we talk
you
later
pop
on.
over. Yeah, if you're about, pop over. I'm not paying, so you're more than welcome to come. Someone else is, so you're more than welcome to come. Anyway, we're moving on because I know people. Okay, HMO Management Regs 2006. The reason why it's so important. What have I missed? About licensing. Oh no. Okay. The HMO Management Regs 2006. Again, this for me is probably the most important thing about managing HMOs, because this is where I see the majority of the prosecutions. It's not because someone doesn't have a license. I fully accept there are quite a few still going through court at the moment. I probably get 2 or 3 court decisions a day about landlords who have not got a license when they should have done, mainly in London. I don't know what it is about London, but mainly in London. But I do see quite a few. But in terms of council prosecutions, they will definitely look under the HMO Management Regs 2006. The thing to remember is the 3rd bullet point down here is unlimited fine per duty. So there are a number of duties upon an agent stroke landlord, or the person deemed to be managing the property, which in most cases will be you as the landlord, and most cases will be the agent. In that particular sense, there is an unlimited fine per duty, and there are a number of duties which we'll cover over the next few slides. So this is the HMO Management Regs 2006. If you Google that, you'll come up with the legislation. There are 2 versions. There's one for England and one for Wales, just to make you aware of that. Okay, so in terms of the requirements, the first one, which is quite, which I've seen a number of councils prosecute on, is the notice of the manager in a prominent position in the HMO. So if you have 3 friends sharing a 3-bedroom flat, if I go into that 3-bedroom flat, there should be a notice of your details on there or your agent's details. Now, the logic behind that is if the local council turn up, or the police turn up, or the antisocial behaviour team turn up, they can very clearly identify quite quickly who is managing that HMO. That's the reason why I assume they have that notice. So that notice does need to be there. And again, I think some people will say to me, take a picture of that HMO when you're doing your checking inventory, because that very clearly shows it was there at the very start of the tenancy. Because as you probably know, a tenant might use it for other purposes. So for that perspective, it will always be good to evidence that the notice was in presence when you first moved that particular set of tenants in. Safety. And this is where the fire safety comes. This is quite a generic section in the HMO management regs. It just talks about safety. Is the property as safe as it could be? And that's where the fire risk part of it comes from. So again, fire risk in particular is going to be probably the most important. What safety measures do you have in place to protect the tenant? So window restrictors, for example, would be one, to stop people falling out windows. That would be one probably very clear obligation. Fire safety, as we've talked about, all those things that you would need to look at in relation to how safe a particular HMO may or may not be. Water and drainage. So in the legislation, it talks about making sure that the pipes are free from frost, or could be free from frost. So again, like tonight, last night there was a relatively heavy frost down here on the south coast. So from that perspective, is your pipe work in the loft being protected from frost? So they talk about lagging your pipe work. So if the environmental health officer, in a sense, thankfully, they probably won't go into the loft. But if they did go into the loft, they would probably expect to see your pipe work lagged. That would be a requirement. Water tanks are covered. If you have an older property that has a water tank, then they would expect it to be covered to protect debris and rubbish and potentially dead animals falling into the water supply. Had that once. We had a dead squirrel on one of ours. But yeah, from that perspective, they are the things that you will be obligated to do. And these are, as I said on the previous slide, these are defined as duties. These are what you're obligated to do. So for each duty that you have, there is a fine if you don't do it. So if you didn't protect the pipework and you didn't have a lid on your water tank, that's 2 duties. And that could be an unlimited fine for both of those duties, for each, shall I say. So you can see how potentially under the HMO management regs, the fines could easily rack up in relation to what you should or you shouldn't be doing as an agent or manager of the HMO. Then it talks about maintaining pipe work, and there's a whole list of things that you are obligated to maintain. Cisterns, ball valves, stopcocks, taps. There's a whole list. And again, they are falling under the duty. So if you don't do that, that is a fine if the council wanted to go down this route. And this is why it's so important to understand this is a proactive requirement. This is not when the council turn up and tell you you've got 1 week to do this or 30 days to do this. If they turn up and you haven't done it, then they can fine you without notice. There is no notice required to be given by the local council in relation to the HMO Management Regs 2006. Hence why it's a very dangerous piece of legislation for landlords and agents, obviously. And then in terms of gas and electric, you must provide them within 7 days of request. So your copies of your gas safeties and your EICRs, your electrical installation condition reports. If the local council requested it, you must provide it to them within 7 working days. Okay. And then the next page of requirements, if anyone wants to read them in more detail, if you just download the HMO Management Regs 2006 English version, they're about 4 pages long, just to give you an idea of the complexity and the length. And then it talks about common parts, and this is basically where it's really generic. And this is where my client in Reading got caught by the dirty shower tray and also the dirty toilet seat. So common parts, basically everything apart from the bedrooms. That's what they define as the common parts. Everything outside of the bedrooms, hallways, stairs, lounge, kitchen, all of that falls under the common parts. Basically where 2 people are sharing facilities, which they will do in terms of the rest of the house. So basically everything apart from bedrooms, keep in good order. That's what it talks about. It doesn't give any great detail beyond that, but keeping good order is probably quite a high threshold. So just be wary of that. Appliances maintained and kept in good order. So again, that's really important to look at. So appliances are not statutory an obligation of the landlord, but under HMO regulations they are. So HMO regulations put more emphasis upon a person that's managing that particular property and owning that particular property. Waste disposal, which I know in Nottingham is one of the biggest issues. Sufficient bins for each household And you have the obligation, as in the person managing the HMO, has the obligations to make sure that any rubbish that's left behind by the tenants is removed. So when they all move out and they leave all their stuff behind, or bits and pieces outside thinking the dustman's going to pick it up, and they don't, then you would become liable in that sense in terms of removing that rubbish stroke waste. You'll be glad to hear they do have some obligations as the occupiers, and that is not to frustrate you in terms of your management. So if you want to access the property to do an inspection or deal with the cleaning, they must let you in. And if they don't let you in, you've got to keep a very clear evidence trail of that. So if the council do turn up and say, well, actually, there's a dirty shower tray and there's a dirty toilet seat, you can say, well, actually, we send in the cleaner once a week, but the cleaner couldn't go in because they were refusing him or her. So all these things are really important in relation to building up your defence in the event that you do face a prosecution from the local council. And then the last slide, you'll be glad to hear, and this is the main reason we have HMO legislation. And I will probably at some point do a fire risk webinar for you, is the 5 steps. And again, I know it's quite hard for me to define what you need for each property, but each property is going to be slightly different. So again, you've got to identify the fire hazards. Where are the fire hazards? So as you could probably see from one of the prosecutions, it's the doors. So you don't always have to have fire doors, but you should have well-fitting doors, because a well-fitting door can prevent the spread of a fire by 30 minutes. So even though it's not a fire door, because it's well-fitting, it actually does offer additional protection. Polystyrene tiles, as per that original prosecution, again, that would be a high fire risk. So all these things that you need to look at in relation to reducing the risk to a tenant. So for all HMOs, I would argue you should have a Fontaine lock on the inside of the front door. Now, that's normally a mandatory requirement for the larger HMOs, but even in the smaller HMOs, that would be something I would absolutely encourage a landlord to be doing, or an agent. So fire hazards, what are the fire hazards? What have you done to minimise? The people at risk, maybe you have a particular tenant with a disability, which you may need to be looking at. Evaluate the risk. As I said, what do I now need to do to minimise that risk? Probably as important as most of them on there is record the findings. So that's why you should have a fire risk assessment for every single HMO that you do or you have. In most cases, for the mandatory licensable HMOs, the council will do the fire risk assessment on your behalf. But for all the smaller HMOs, as in the 3 or 4 people, then you would have to do it yourself. But again, in the event of a fire, what did you do to minimise the risk to the tenants and occupiers? And then review it periodically. Now, for fire risk, I would probably say I would do it once a year. Just revisit and say, is this fire risk assessment up to date? Is there anything I need to do? So that would be my position. Maybe once every 1 to 2 years, depending on the size of the HMO, I would revisit in relation to the fire risk assessment and see if it needs updating. And I'm mindful of time. And then my very quick summary, just to put into one slide what I've covered today. As I said, first, top left, it's the people that make it a HMO. The next one to the right, more laws relate to HMO. So yeah, the HMO Management Regs 2006 is the big piece of legislation that applies. As I said, councils are much more proactive. They spend a lot more time dealing with HMOs. That's probably their biggest caseload, is HMOs, because evidently that's where most of the problems come from. What you've got is that we have a catch-all situation where probably their most awkward ones are mandatory licensable HMOs, but because they deal with HMOs, they also obviously catch the smaller ones, and the ones that potentially aren't of high risk get caught by the legislation, which is why you've got to understand what is a HMO to understand what type of HMO that you do have. As I said, they're all criminal offences. Not complying with the legislation is a criminal offence, and having a prosecution under the HMO Management Regs 2006 can stop you from being a landlord. So again, for me, really important. I can't understate the importance of understanding the HMO Management Regs 2006. Again, completely different to managing a family home. Family homes, as a general, are a lot simpler compared to a HMO. So you may have to have different processes required. You might have to do more inspections. You might have to have a slightly different application process. you might have to have a different repairs process when you're getting dealt with complaints about issues in the property, because don't forget, you have a higher threshold when you're dealing with a repair that's been notified to you by a HMO tenant rather than a family tenant. And then the last point I said, understanding is crucial, hence why I'm having this course, which I fully appreciate. It's quite difficult to explain everything in 53 minutes, but that's what I've tried to do over that period of time. As I said, there is a recording. If you need to go back and just refresh on something that I have or haven't said, then you're more than welcome to do so, and that will go up on my YouTube channel at some stage today. And that, thankfully, for those that are multitasking, is me finished. So you can go back to doing whatever you need to do without multitasking. Any questions?
No, to me, it's just a refreshing. It's a refreshment course to me. Thank you.
Brilliant, Henry. I know you don't deal with that many HMOs, so yeah, not a problem at all. Any other questions? I'm not too sure if anyone else is alive, but there might be. I don't know. Maybe I've scared them all rigid. Paul, I can see you've unmuted. Or maybe not.
Just to say thank you very much.
I hope you got your office cleaned out, Paul. Hopefully that was one of the benefits of the last 53 minutes.
Not as quick. So it was still useful to go through some of those things, and just as a reminder, so it's useful. Thanks a lot, Daryl. Quality is
okay. Yeah. Okay, guys. I appreciate there doesn't seem to be any text any questions in the chat box apart from Hen you saying hello. And John, as always, great to see you. Or not see you, but well, actually I did see you, but see you and speak to you. Have a great weekend, everyone. As I said, you go to my YouTube channel at some stage today when I've uploaded it. But thank you as always for attending, and I wish you a good weekend. And hopefully I'll speak to you and see you guys very soon. Thank you.